final speaker is Dr. Wayne Sumner. He's a Canadian philosopher noted for his work on normative and applied ethics, political philosophy, and the philosophy of law. He studied at Toronto and received his doctorate from Princeton and is a fellow of the Royal Society of Canada. He is at the University Professor Emeritus of Law and Philosophy here at the University of Toronto. His research interests include ethics, political philosophy, philosophy of law. He's written on topics such as abortion, the moral foundation, the right, a book called Welfare, Happiness, and Ethics, The Hateful and the Obscene, Studies in the Limits of Free Expression, and finally, Assisted Death, a study in ethics and law. I want to welcome Dr. Sumner.
Thank you very much. I'm the odd person out here, no PowerPoint. Just have to listen to me. I think the easiest thing for James and I to do on our side of this question is to make the case in favor of legalizing physician-assisted death. All you need to do in order to make that case is to appeal to two core values in any liberal civil society, including ours. The first of them is compassion, and in particular, compassion for those who are suffering. And what compassion for those who are suffering at the end of life requires is access, above all, access to high-quality palliative care. And the rationale and the goal of palliative care is to relieve suffering in the dying process, to ensure as much as possible that patients can die a good death, a death with dignity. Physician-assisted death in that context is an additional end-of-life option that enables a minority of patients for whom the other options available to them in palliative care are insufficient to die a good death, a dignified death. And there always is that minority. We know that from the jurisdictions that have legalized one or another form of physician-assisted death. James mentioned how in Oregon, well over 90% of patients who opt for an assisted suicide are already in hospice. They're already in palliative care. For them, the otherwise available options for end-of-life care are insufficient, but nothing, and in terms of their own evaluation of their lives, nothing will alleviate their suffering or allow them a dignified death except the option of a physician-assisted death. Denial, in that context then, denial of legal access to physician-assisted death for those who need it is not only not compassionate, it's cruel. And compassion is, as I say, one of the core values in any decent society. Denial of access to physician-assisted death simply leads to unnecessary and avoidable end-of-life suffering. The second core value is respect for autonomy. Respect for autonomy basically consists of allowing persons to be self-determining. That is, to make the major decisions about the course of their own lives. In medical contexts, autonomy is the underpinning of the doctrine of informed consent, which is the centerpiece of medical practice now. In end-of-life contexts, respect for autonomy takes the form of giving patients control over their own dying process, letting them be the determiners of how that is going to go. When physician-assisted death is available, as we know, some patients will choose it. If we respect patient-informed choice with respect to other medical decisions, then we must respect patient-informed choice with respect to this one as well. And then in this context, denial of legal access to physician-assisted death is denial of autonomy. So that case in favor of legalizing physician-assisted death seems to me completely compelling. However, there are arguments on the other side. Basically, two kinds of arguments, as I understand them. First of all, ethical arguments. That is, arguments that, for one reason or another, physician-assisted death is just wrong. It violates ethical principles. And then secondly, what I'll call practical arguments. Arguments that do not deny that physician-assisted death may be quite ethical, but take the form of contending that it can't be safely legalized. Now, I just want to say parenthetically that the arguments that I'm going to be considering are all secular arguments. I'm not considering any religious arguments against physician-assisted death, simply for the reason that in a secular, pluralistic society like Canada, religious reasons, faith-based reasons, cannot be used as a basis for public policy. No adherents of a particular faith community can be permitted to impose their views on those who don't share their particular faith. So the arguments, all of the interesting arguments on the other side are secular arguments, either ethical or practical. Now, despite the fact that I do ethics for a living, I'm going to set the ethical arguments aside for a moment. If I have time later on, I'll come back to them. I'll simply say right now, dogmatically, I don't think there's any credible ethical objection to physician-assisted death that doesn't apply equally to the other measures that are available in palliative care and already legal and widely accepted as ethical in this country. But I'll postpone that. I want to deal with the practical arguments. So here the argument basically takes the form of saying that physician-assisted death may be ethically quite acceptable, but it's not safe to legalize it. And these are the concerns about abuses, slippery slopes, increasing risk to vulnerable groups, whichever group you have in mind, the elderly, persons with disabilities, the poor, women. The first point I want to make is just a very simple one, that this is a factual issue. It's an empirical issue. And where we're talking about a factual issue, not an ethical one, but a factual one, then it's important to rely on evidence. One hears a lot of claims being made about how, if legalized, the conditions or safeguards for physician-assisted death will inevitably be abused or will lead to slippery slopes or whatever. But those claims are very seldom backed up with any evidence. And yet, we have a lot of evidence. And we have a lot of evidence because other jurisdictions have gone ahead and already done what we're contemplating doing in this country. Oregon legalized physician-assisted suicide in 1997. The Netherlands and Belgium both legalized euthanasia in 2002. So we have from those jurisdictions over a decade and a half in the case of Oregon, of experience with legal regimes to draw on. And they have been massively studied. First of all, there are innumerable reports that are produced by the governing bodies in those jurisdictions about the incidents and conditions of physician-assisted death, but also a great deal of scholarly attention by social scientists to how these policies have worked out. So we have masses of evidence. Now, George mentioned I published a book called Assisted Death. This came out in the summer of 2011. I devoted a chapter of that book to working through all of this available evidence. And on the basis of that review of the evidence, I drew two conclusions. First of all, there is no credible evidence of abuse or risk to vulnerable groups in those jurisdictions. Secondly, physician-assisted death could be implemented safely in Canada with appropriate safeguards. And it was on the basis of those conclusions that I became an advocate for legalization. Now, there is an end to it. I've just told you it's safe to legalize, no problem of abuse, slippery slopes. You might be thinking, well, why should I trust this guy? He's, after all, a partisan. This is a debate. He's on the side of legalization. Can he be trusted? Is he a credible source? And I think that's a healthy kind of skepticism to be applying here, because there are a lot of claims and counterclaims about what this evidence shows some claiming that it shows there are massive abuses, others claiming that no, it shows everything's just fine. Most of those claims and counterclaims are being made by advocates on one side or the other. When you find that situation, then one piece of good advice is to seek out credible, trustworthy sources that are not committed, that are not partisan, that are neutral as far as the debate is concerned, and that can be trusted to look at the evidence objectively without any particular axe to grind. And we're lucky in Canada that over the past 3 years, we've had 3 such sources to rely on. The first was an expert panel that was put together by the Royal Society of Canada to look into the issue of legalizing physician-assisted death in Canada. It produced a report in November 2011 called End-of-Life Decision-Making, one chapter of which was entitled International Experience with Laws on Assisted Dying. And in that chapter, what the panel did was to look at all of the evidence from those jurisdictions in which the practice had been legalized. This was their conclusion. I quote, "Despite the fears of opponents, it is clear that the much-feared slippery slope has not emerged following decriminalization, at least not in those jurisdictions for which evidence is available. What has emerged is evidence that the law is capable of managing the decriminalization of assisted dying and that state policies on this issue can reassure citizens of their safety and well-being." That's the Royal Society expert panel. Second, the Select Committee of the Quebec National Assembly. Everyone knows, I suppose, that Quebec was on the verge of passing Bill 5052, which would have legalized euthanasia in that province. That process began with a select committee, an all-party committee, that was set up to hold public hearings on the issue of legalization, to hear from experts, and to review all of the available literature, and also to visit both the Netherlands and Belgium as model examples of legalization. The Select Committee produced its report called Dying with Dignity in March 2012, and this was their conclusions. A number of points were raised concerning the potential abuses and the repercussions of an openness to euthanasia. These fears, while legitimate, were not substantiated based on what we found in the European countries where euthanasia is practiced. Our mission overseas allowed us to see for ourselves how the practice has evolved. What we typically heard, even from opponents, was that euthanasia has not led to any abuse of the vulnerable. And again, medical aid in dying does not endanger the common good. Rather, it forms an integral part of it by offering one more option for those nearing the end of their lives, without posing a threat to society's most vulnerable members. We are not saying that there are no risks in allowing medical aid in dying, but we do believe that just like Belgium and the Netherlands, Quebec society has what it takes to avoid them. Lastly, as many of you will know, there is a constitutional challenge to the euthanasia and assisted suicide laws in Canada underway, which will reach the Supreme Court sometime this year. This is Carter versus Canada. This case was argued at the trial level in November and December 2011 before Justice Lynn Smith of the British Columbia Supreme Court. She produced a judgment which was released in June of 2012. Now, she heard from expert witnesses on both sides of the question of how legalization has worked out in those countries in which it has been attempted. And she conducted an extensive review of the available literature on this question as well. Her judgment runs to 400 or 500 pages. It's extremely long and very closely argued. But on this particular question, these were Justice Smith's conclusions. The expert opinion evidence from persons who have done research into the question is that with respect to all 3 jurisdictions, this is Oregon, Netherlands, Belgium, the predicted abuse and disproportionate impact on vulnerable populations has not materialized. Empirical researchers and practitioners who have experience in those systems are of the view that they work well in protecting patients from abuse while allowing competent patients to choose the timing of their deaths. My review of the evidence leads me to conclude that the risks inherent in permitting physician-assisted death can be identified and very substantially minimized through a carefully designed system imposing stringent limits that are scrupulously monitored and enforced. So those are the three sources that we have available in this country who have gone through the same evidence I did. A panel of experts consisting of doctors, lawyers, and philosophers, an all-party committee of the National Assembly, and a judge. And they all came to the same conclusions I did. That is, there's no credible evidence of abuse or risk to vulnerable groups in those jurisdictions. And secondly, physician-assisted death could be implemented safely in Canada with appropriate safeguards. So you don't have to just take my word for it.